Two different cases in the Southern District of Illinois. One has a ruling, the other we're still waiting on, and it deals with the state's gun and magazine ban and the registry. That is set to take effect January 1st. That is 2 weeks from today. On this December 18th, Greg Bishop with you. It's Bishop on Air. You can find me here each and every weekday morning. I want to thank everybody for tuning in. Like, subscribe, hit that notification bell, share it with your friends, and let them know that you tune in and why you tune in. Also, by the way, the contest we did have for people who shared on social media, I sent out some stuff. So those of you know who you are, you will be getting some stuff. And if you want to be sure to support the program, you can do that by going to my Bishop on Air store, where you can find a whole host of different products, including this product here, of a judge quote saying that the law is both stupid and very likely unconstitutional. That was concerning a law about crisis pregnancy centers possibly facing lawsuits if they didn't tell patients about abortions. So interesting quote there, but you can even get a teddy bear with, teddy bears are more regulated on it. So you can find different ways to support the program, including getting a whole bunch of swag with Bishop on Air on it. All right, so let's get to it because there's a lot of anticipation of what's going on. Of course, last week, you had Judge Stephen McGlynn. He heard the case from the federal firearms licensees of Illinois, where you had the challenge of the state's registry. They were asking for that January 1st deadline to be suspended while the case plays out. And of course, that January 1st deadline rapidly approaching, but on Tuesday down in East St. Louis, the judge did hear oral arguments in that case where he said he was inclined to not issue that preliminary injunction against the January 1st deadline, but hadn't made his mind up. And he said that he was going to issue a ruling promptly. So you have that case that's still pending. And just to take a look at the docket here, you can see that on the 15th, which was Friday, the plaintiffs, they did file a motion to dismiss opposition filing. So essentially, I mean, this is a short little read here, but this is from the plaintiffs, in this case from the federal firearms licensees of Illinois, essentially arguing that the state, their motion to dismiss is improper. They go on to spell out why this is the case. They say, to the extent the state argues the associational plaintiffs do not have standing on behalf of their members, plaintiffs contend that question was settled in Ezell versus Chicago. Plaintiffs, Gun Owners of America, and others have explained that the concerns and confusion they have heard from their members regarding registration, and it could not give definitive advice to their members due to the constant revisions and frequently edited guidance published by the state. That is sufficient to establish associational standing. So that's one of the plaintiffs, countering what the state said, that the state said that the plaintiffs had no standing because they're just an association. They have no standing. There's been no people who have actually been injured by this. But clearly, you've got the plaintiffs saying that their members are confused and they can't actually give their members any advice because of the constant revisions of frequently edited guidance provided by the state. The plaintiffs also went on to say that plaintiffs believe the arguments presented in their due process claims, even if not enough to earn a preliminary injunction, are clearly enough to state claims sufficient to survive a motion to dismiss. As the Illinois State Police continue to tinker with as yet unfinalized regulations governing numerous vague terms, plaintiffs believes it's important for gun-owning residents of Illinois to have proper notice, and the upcoming registration deadline could cause dramatic problems. The state has thus far not offered any extensions to the deadline, even as it's in Kafkaesque fashion will not adopt final regulations until after the deadline's passed. So that's what happened in the federal firearms licensees of Illinois case on Friday. No ruling from Judge Stephen McGlynn on Friday in the FFL of Illinois case. The only thing Friday was a memorandum in opposition of the motion that the state filed to dismiss the plaintiff's motion. So we will be tracking this and see when Judge Stephen McGlynn's going to issue a ruling in the federal firearms licensees of Illinois case, looking to postpone that January 1st deadline. FFL of IL, they said that they're not looking to strike the entirety of the law. They're just really looking to delay that January 1st deadline. That's what they're looking for. But that wasn't the only case that's pending in the Southern District of Illinois. If you recall, back in October, the Langley plaintiffs in the Southern District, attorney Thomas Magg, these were all cases that were lumped together in the Southern District that went up to the Seventh Circuit on the Second Amendment question, right? And for those of you who just now tuned in to this program, we've been tracking this step by step by step. And I do plan on, it's going to take a little extra work, but I do plan on trying to do a live to tape documentary of, you know, the past year and how we've gotten to where we're at. So maybe I could try to do that as a live program sometime heading into the holidays. But regardless, you had the cases in the Southern District of Illinois all lumped together, a variety of them, federal firearms licensees being one, the State Rifle Association being another, National Shooting Sports Foundation. You've got the Langley plaintiffs with Thomas Magg representing them. So all these cases put together. Stephen McGlynn issued a preliminary injunction back in April, lasted 6 days before the states got a stay from the Seventh Circuit, essentially saying that McGlynn's injunction is not in place. So that only lasted 6 days, where people called it, Freedom Week. But the Seventh Circuit handling these consolidated cases. So Thomas Magg, who actually filed the first case in this entire saga of cases, filed it in state court, and then it got transferred to federal courts, and now in federal courts, made it all the way to the Seventh Circuit. But Magg took the vagueness arguments that he had, because he had a vagueness argument, he had a Fifth Amendment argument, and he had the Second Amendment argument. So all the lumped into cases that ultimately went to the Seventh Circuit were just dealing with the Second Amendment. But Thomas Magg brought out the vagueness argument and argued that in October. And if you missed that, you can check that out in some of my previous videos and reviews of all of this. So if you look at the docket for the Langley plaintiffs case here, we've been waiting for this, and I didn't mean to not check on Friday, but actually on Thursday, Judge Stephen McGlynn issued an order. And this is from the oral arguments that happened in October. So on Thursday, Judge Stephen McGlynn denied a motion for partial summary judgment. So the Langley plaintiffs were looking for partial summary judgment. They weren't looking for summary judgment of the entire law. They were looking for partial summary judgment on specific aspects of the law being too vague. Judge Stephen McGlynn on Thursday denied that partial summary judgment motion. Let's go ahead and take a look at some of what McGlynn wrote here in his 17-page opinion. All right, we'll go through this as best we can in the time that we have allotted here. But you've got the case again that was brought forward. Pending before the court is a motion for partial summary judgment on counts 4 and 6 filed by plaintiffs Jeremy Langley and others pursuant to Rule 56 of the Federal Rules of Civil Procedure. Defendant Brendan Kelly, the director of the Illinois State Police, filed a response, which the Langley plaintiffs filed a reply. Director Kelly filed an extensive motion to supplement his response, containing over 450 pages of deposition testimony and additional exhibits. The Langley plaintiffs filed a response to this supplement, having been fully informed of the issues presented. This court denies the Langley plaintiffs' motion for partial summary judgment, arguing that the Protect Illinois Communities Act is facially unconstitutional on vagueness grounds. So that was the argument that the Langley plaintiffs were making, that it was facially unconstitutional because it's too vague. Then goes through the relevant factual and procedural background as to how this case got to where it's at, kind of spelled some of that out for you. Then the Langley plaintiffs filing that motion for summary judgment back in May. Notably, neither the Barnett plaintiffs nor any of the other plaintiffs in the other two cases joined the instant motion. The pending motion concerns 2 counts in the Langley plaintiffs' original complaint, specifically those alleging the specific provisions of statutes in question are unconstitutionally vague. Conversely, Director Kelly argues that the statute is not unconstitutionally vague, that the Langley plaintiffs failed to meet their burden under the rigorous standard required for a facial challenge of unconstitutionality, and that even if the challenged portions were ruled unconstitutional, those provisions should be severed from the whole because of the Illinois state statutes of statutes. Oral arguments, as we covered, happened October 11th, and if you missed the oral arguments tweets, you can find those if you go back to my X page, or you can even just go and look at some of the YouTube videos from this channel around that time. So it then goes into the applicable law and legal standards, and again, this is the Langley case, not the Federal Firearms Licensees of Illinois case. We're still waiting on the Federal Firearms Licensees of Illinois case that Judge Stephen McGlynn did say he's inclined to not to give an injunction on, but he said he hadn't made his mind up yet. So we'll see what the Federal Firearms Licensees of Illinois case ultimately means. But when it comes to the Langley case that Attorney Thomas Magg argued back in October, that has been denied, and that's what we're looking at here. So I want to go through and just read some of the final parts here. As you look at the 17-page document, the Langley plaintiffs argue that the Act's 10-round capacity restrictions for rifle magazines and 15-round restrictions for pistol magazines is ambiguous because there exist some pistols and rifles that use identical magazines. The Langley plaintiffs specifically cite the 9mm Beretta M992 pistol and the Beretta CX4 carbine as examples. They also argue that such weapons with interchangeable magazines are ubiquitous. Additionally, the Langley plaintiffs provide numerous examples of weapons that they argue do not fit the AR or AK category, which they claim infuses impermissible vagueness into the statute. In their oral arguments, the Langley plaintiffs argued that it was impossible to determine exactly what an AR-type weapon ceases to be an AR-type weapon for purpose of sale. In other words, a person of average intelligence and experience would be wholly unable to determine which feature must be eliminated or altered in order to render an otherwise impermissible AR-15 legal under the statute. Judge McGlynn also writes that the Langley plaintiffs rely heavily on some case law, where it's Springfield Armory versus the City of Columbus. They then analyze some of that case law. But I do want to just get to some of the other major parts here, where you've got the judge, Stephen McGlynn, talking about the U.S. Supreme Court repeatedly holding that imposing an intent requirement on an otherwise vague statute could save a law from finding an impermissible vagueness. Goes on to say that you've got some of the other case law review that the judge is doing here. Thus, while not dispositive, the presence of a cincture or mens rea requirement, it parries the primary thrust of a vagueness challenge. PICA contains one of the 4 explicit model penal code mental states knowingly. The Langley plaintiffs argue that PICA criminalizes mere possession of prohibited items and points to Staples versus United States as established the mens rea requirements that applies here. Mens rea is like the intent. And that's, did you intend to violate the law? This may be so, but their argument does not negate the fact that unlike the National Firearms Act at issue in Staples, PICA does contain an explicit mens rea requirement that requires the government to prove that the accused knowingly possessed a prohibited firearm or ammunition feeding device. This also surmounts the hurdle discussed in the People's Rights Organization, in that the mens rea requirements in PICA is more than mere knowledge that certain magazines exist. Goes on to say that Director Kelly argues that the mere existence of a small number of interchangeable magazines does not leave the public hopelessly incapable of discerning what the act requires. He asserts that the number of off-the-shelf weapons with interchangeable magazines is much smaller than what the Langley plaintiffs claim, and that their claims are exaggerated and irrelevant. Kelly also argues that the definition at issue is not that of AR type or AK type, but that of a quote, assault weapon more generally. Additionally, Director Kelly argues that ISP's duty to publish an annual list of prohibited firearms further clarifies which weapons are proscribed. And again, that's something that state police do each and every October 1st, is they can file new rules essentially spelling out what is and what is not banned. And again, what we're looking at here is the Langley case, not the federal firearms licensees of Illinois case. That case still pending. Haven't seen Judge Stephen McGlynn issue a ruling there. But the Langley case that was heard on vagueness grounds back in October, we did get a motion to deny or an order to deny the motion for partial summary judgment. And that's what we're reading here is the filing from Judge Stephen McGlynn that was filed Thursday. Goes on to say, finally, he argues, and this is what McGlynn is saying, that Illinois State Police Director Brendan Kelly argues that the Langley plaintiff's use of hypotheticals is forbidden in a facial challenge for vagueness, stating that concocting a scenario where any uncertainty about the 10 versus 15 round threshold could arise requires plaintiffs to speculate about hypothetical or imaginary cases, which is not appropriate for a facial challenge. Then they cite some case law. McGlynn goes on to write, the Supreme Court has been clear that the holdings squarely contradict the theory that a vague provision is constitutional merely because there is some conduct that clearly falls within the provision's grasps. Thus, the fact that the statute has some valid provisions is not sufficient to defeat a facial challenge on vagueness. With this in mind, to survive this pre-enforcement facial challenge, the defendants must only demonstrate that the statute has a discernible core. While with the enforcement of a statute will inevitably present many uncertainties at the margins, the Seventh Circuit has said that the resolution of those edge questions arises from the enforcement of a state law in a principal role of the state's courts. Goes on to say that you've got plaintiffs that they want to deem the law vague by identifying situations in which state officials might take an untenable broad reading of the language and then predicting that they will do so. It is far preferable, however, and more respectful of our judicial colleagues to assume that they will act sensibly and resolve the open questions in a way that honors candidates' rights under the First Amendment. And that was a quote from some other case law. It goes on to say that the fact that there exist pistols and rifles with interchangeable magazines does not mortally wound Pica. Rather, this is clearly a so-called edge question. The fact that the Langley plaintiffs' experts indicates that 6 of the 43 AR-type weapons explicitly cited in the statute are not substantially similar to the AR-15 is not by itself enough to make the statute unconstitutionally vague. Again, this is another edge question. The Langley plaintiffs' own experts demonstrated depositions that they understood there to be a discernible core to Pica and that they could advise their customers on which magazines were Pica compliant. Thus, the matter of enforcement is better addressed in an as-applied challenge. So really what I think I'm taking away from this is that you've got Judge Stephen McGlynn making it clear the difference between facial challenge, which just says, hey, before this thing's even applied, we're challenging it because it's unconstitutionally vague. He's denied the motion for partial summary judgment on vagueness grounds. So denying that in the Langley case and seeming to highlight that, well, it's going to be the as applied that's really going to be the crux here to address all of this. So it goes on to say McGlynn's order on the Langley case filed on Thursday. Moreover, the Langley plaintiffs asserted at oral arguments that the Illinois legislature could make the spring from a ballpoint pen illegal because it's nearly identical to the spring of the AR-15 buffer. Nowhere in Pica are springs or screws or bolts, for that matter, criminalized. While the tactic of absurd reduction may be more appropriate for an as-applied challenge for vagueness, this type of hypothetical or imaginary cases is inadequate and insufficient to the instant facial challenge of vagueness grounds. Therefore, the Langley plaintiffs' facial challenge has not met constitutional muster. Because of the inadequacy of their challenge, this court does not reach the question of severability and whether or not the Illinois statute of statutes will save valid portions of PICA. For this reason set forth, the court denies the Langley plaintiff's motion for partial summary judgment, and they have failed to meet their burden to prove the specified provisions of PICA text unconstitutional because of facial vagueness. There are a number of outstanding legal challenges to various parts of PICA and the larger statutory scheme, but by this order, the court does not address any arguments suggesting that there may be other viable challenges to PICA, to the ISP enforced registration requirements, or to any other part of the statutory scheme included on an as-applied basis or under any other constitutional basis. So again, that was issued by Judge Stephen McGlynn on December 14th. So that was Thursday. So we're still waiting on the Federal Firearms Licensees of Illinois case to be determined. They're asking for that delay in the January 1st deadline, and whether or not that actually happens, we shall see. We'll be watching that closely because Judge Stephen McGlynn with the FFL of IL case said he would issue a ruling promptly. Have yet to see that. And will it come out before Christmas? That's the anticipation. Could it come out today? We shall see. But you saw the Langley case. We just went through some of the things that the judge laid out in his opinion, denying a motion for partial summary judgment against the state's gun and magazine ban. So that was against the ban, right? That was against the ban, Langley case. The much more narrow case seeking a preliminary injunction or a temporary injunction, that's what's still pending in front of Judge Stephen McGlynn from the Federal Firearms Licensees of Illinois. Hopefully you're not super confused. We will break this down some more as the things progress, but as it stands right now, that January 1st deadline is still very much in place. So we'll keep you posted on more as all of this plays out. It is Bishop on Air. Thanks so much for hanging out. You can find me anywhere. Just search Bishop on Air on X, on Twitter. Same thing, Facebook, YouTube, like, subscribe, hit that notification bell, and be sure to follow along there, all right? It is Bishop on Air. Thank you so much for hanging out, and we've got just another segment to do, so stay tuned. We'll get to that next here with Bishop on Air.